Dear friends, colleagues, I can see that we have a lot of people in here, but let's try to be a little bit quieter. This roundtable discussion is one of the longest in this forum, and is probably one of the largest in terms of the audience. This entails a number of difficulties and inconveniences. And I'm trying to talk into the mic now. So as I said, there are a number of inconveniences here, because we need to divide our speakers into two parts. I don't know if anyone is aware of which part of this roundtable discussion they speak. Nevertheless, let's begin and not waste time. A few words of introduction. I'd like to pay your attention to the following. Our roundtable discussion is not just a Russian-centered roundtable discussion, it's a Russian-French discussion. And this is not by chance that it happens so. The thing is that two of our countries find themselves in a similar situation in terms of the law of obligations. We have just reformed the general provision on obligations, whereas in France there has been an ongoing reform of the law of obligations, and at this point in time it reached its final stretch. They have a plan of actions and a schedule for the implementation of this reform, and there are a lot of issues that we faced, and there are a lot of issues that we currently face after the two federal laws were adopted that constituted the reform. All of these issues were faced by our French colleagues, and this is probably why our French colleagues were very interested in this roundtable, and I think it would be of interest to us to learn about their experience and practices. The second point I wanted to make here is as follows. Well, if we leave the reform about legal persons in Chapter 4 aside, we still have a new language on Lien law, but there are also other provisions, and the reform there is fragmentary. It's very specific, and every specifics, every point of application is of great interest, and it leads to specific conclusions and consequences. I would like to ask those who will talk about these specific aspects to keep in mind other changes as well, and if possible, refer to the general aspects, to the general background, to the forest where these new trees grew. I think when these changes were implemented, or rather when the entire concept was put in place, we tried to keep in mind the general ideas around which all these changes will be implemented. We were interested in the moral values that could be put into foundation of the trends in our law of obligations. So finally, in the civil code, we have the overall principle of good faith, but if you look into several other chapters, you will see that there are a lot of new notions that are directly or indirectly related to this principle. We kept in mind the ideas related to the protection and registration of the interests of the weakest party in the contractual obligations. Whether we succeeded or not, we'll have to discuss that. Let me just point out one thing. In the accession contract, we have now a new norm, which is probably somewhere in the very end, listed somewhere in the end. But I think it's an important norm, which could be called the norm on unfair contracts. It goes beyond the accession contract. And the third point that I wanted to make is the judge's discretion. When the bill was first considered in 2004, 2006, there was a very big role assigned to the court, so that they could use the general provisions of the civil code. Today, the civil code goes beyond what had been achieved. Another point worth making is related to something that is as relevant to the Russian colleagues and the French colleagues. Integration of institutes that were borrowed from foreign law. And this is something that all legal systems face. In fact, today, people do not even remember that they are using borrowed notions or institutions. We have just finished the roundtable on corporate law, and the majority of speeches and presentations there were on the specific types of deals that were introduced into our legal system within the past 20 years. They were borrowed lock, stock and barrel from the European and US legal system. In fact, very few people remember that we had an institute for legal economics, which was funded by foreign entities. It was responsible for the bill on shareholders 1996, and the civil code did not contain such deals, any information about them. 20 years have passed, and it took us 20 years to untangle the unusual and possibly interesting innovation of 1996. So when the borrowing happened, nobody realized the consequences. But today, we can see the consequences. So when we speak today about some borrowings, when we introduce into our civil code borrowed institutions, and often these are borrowed and implemented without attention to details, there's a risk that 20 years from now we will discuss the consequences of this borrowing the way we do it today, the way we did it at the roundtable discussion on corporate law. So please keep in mind these general ideas, general aspects and foundations, even if you speak on specific issues. I am sure that there will be different issues discussed. We will jump from one onto another, because our presentations usually focus on specifics, on concrete ideas. They don't provide you with an overall picture. We're all legal professionals here. We understand where these issues are, where they're positioned within the overall legal system, so I don't think it is a big problem. I'm sure that jumping between the problems, juggling the problems, is not a big problem, so to speak. I think we can keep in mind the links between these problems. Lyudmila Novoselova, if you do not mind, I would like to give the floor now to her. The speaker is not using the microphone. Well, hello, I wanted to start with you, but now I have to give the floor to another speaker. Please.
Good afternoon, dear colleagues. My original plan was to address a different topic in my presentation. Originally, I wanted to talk about how general liability and obligation norms operate whenever intellectual property transfer occurs. But as we were getting closer to this round table and the topic of it became more and more distinct, I decided to depart from that topic, and in my presentation today I would like to cover a slightly different set of issues, mainly those related to the changes that have been made to the civil code provisions on obligations, the general provisions. First of all, well, of course, everybody has to be held accountable for the fruit of their own efforts, and this is why I would like to draw attention to the provisions that were entered into the Civil Code relating the change of parties in to an obligation, and also the provisions that were entered into the security transactions, the surety provision and the independent warranty provision. If we look at what's changed in terms of regulating relations related to a change of party in an obligation relationship, I think that these changes were very much required, really, and in response to Aleksandr's words, I would like to emphasize that a lot of the provisions on the transfer of debts, those provisions were very highly demanded by practice. For a long time, our case law approached a change of party to an obligation very negatively in the case of such transactions. And every such transaction was around the 99% risk to be deemed void or annulled. So in response to this negative case law, it was necessary to develop, first of all, the theoretical foundations that would really ease the tensions, whereby we're trying to explain that these transactions are part of normal business turnover. It's nothing out of the ordinary, so the job of the lawmakers was to establish a regime for such transactions that would minimize the risk for both the debtor in terms of rights transfer from person to person, and second, to ensure the feasibility of turnover of such rights as an important asset, and also to minimize the risks in such a very specific situation where a party to a contract changes. In my opinion, most of the new provisions in the Civil Code can be very positively evaluated. It is my pleasure to say that now we have an article on the transfer or reassignment of future rights. This is very much in line with the changes that were made to the other articles of the Civil Code. We know that business requires these relations to be regulated. Initially, when such situations arose in practice, very often we heard that what kind of transaction is this? What's the subject of this transaction? An obligation in itself is an abstract thing, and we're talking here about an obligation that doesn't even exist when a transaction is considered. This is an abstraction to the power of two. You are really building castles in the air. That's what people said. Yes, indeed. These transactions are not without risk of a castle in the air or a bubble appearing. Nevertheless, it doesn't mean that the awareness of these negative consequences should preclude us from allowing these transactions a priori. I think it's very important to identify where the problem is and to regulate. Especially that rights assignment channels should be available. The code should be very explicit about it. Currently, the provision that future rights can be the subject of a transaction are directly, explicitly embedded in paragraph 1 of Article 24 of the Civil Code. The code also regulates the timing of such reassignment. Of course, a right cannot be transferred before it arises, and this was explicitly stated. But there is a proviso there saying, unless otherwise specified by the law. People tend to overlook such provisos and reservations because they tend to face provisions at their face value. Only whenever there is a question whether it's dispositive or non-dispositive do we resort to these otherwise case statements. But it says here that something to the contrary may be established by the law, and if you think of it as a paradoxical situation, the law may provide for a situation whereby a future right will be transferred to another person before it even arises. Is that situation feasible? In principle? Well, come to think of it, theoretically, an occurrence like this may arise. The law, on the other hand, should limit the number of such cases in order to prevent abuses, because this rights transfer mechanism retroactively, which means that rights are transferred before they arise, is a legal fiction. It can only occur in a very limited number of very specific transactions, and those cases should be covered for by the law that will enable such transactions subject to a number of very strict conditions imposed on the parties. And another thing that needs to be mentioned as we look at the new version of Article 24 of Civil Code is that it regulates more clearly relations that involve consequences of changing a party in an obligor-obligee relationship, because the obligor is always highly concerned when the obligee changes, the debtor is concerned, and it's our duty to safeguard the debtor from those concerns and trepidations and tensions. Therefore, in the new version, we have a number of important provisions to that effect. In particular, the new Civil Code regulates, specifies very clearly what the debtor should do in difficult situations, complex situations. In other words, when a debtor, for instance, faces a situation where they perceive that there is a multitude of debtors. We know that rights can be assigned and reassigned multiple times, and sometimes the debtor may not be aware of each such step. Now we have a notification procedure for the debtor. If a reassignment occurs, it needs to be notified. There is a number of civil code provisions that have been structured in such a way as to underscore the importance and the requirement of such notification for the debtor, so that they're aware who they are indebted to. And the other role of this notification is that they know exactly at what time the obligor has changed, and that means that they no longer bear the obligations before the earlier obligor. Unfortunately, this is indeed a tricky issue, and in practice it has raised repeatedly a lot of controversy and a lot of inconsistent rulings. But the code has been quite consistent in that regard from the very beginning, and these new amendments only highlight that consistency. Until the debtor knows about reassignment, until they have been notified, and it's a notification procedure, it's a formal notification, not just information rendered by word of mouth. Before that notification occurred, the debtor regards their obligations as continuing. That means all the obligations that bind the debtor with regard to the original creditor remain legally, and the debtor is has the right to appeal to the original creditor, even though that creditor is no longer their creditor. So that situation has been resolved in the new code. The debtor is regarded to be in performance of obligations. If they have not been notified, they are deemed. That doesn't mean that they actually are.
So this is a formal instrument, and the code actually provides in much detail how this instrument can be used. There are a number of complicated cases when the rights are reassigned several times. There may be several notifications in this case, and therefore the obligor needs to understand quite clearly who exactly is the obligee, who is the creditor at this particular moment in time. So the code specifies very clearly who at this point in time formally is the creditor for this particular obligor. If there were a sequence of notifications based on the latest reassignment, it is good that we entered this into the code, because this makes it clearer for the obligor. He will have a better understanding of the relationship. But unfortunately, we never make it 100%, obviously leaving some room for practical implementation. So if we decided to protect the obligor's rights, the debtor's right, if we want to specify rules to be used by debtor, then perhaps another situation should be regulated. This is a situation that arises, and we know that it arises quite often. The same creditor is trying to assign the right to different agents. The code specifies a rule that the assignment of the right takes place in favor of the person who received this right first. So the one who received it first is the actual creditor, is the actual obligee. But the rest of them believe that they are creditors as well, and therefore they believe they are creditors, and they believe that they have the right and the obligation to notify the debtor. They are the ones who believe to be involved in negotiations, and they find themselves in a difficult situation. And of course, for the debtor, it is even more difficult, because there are several creditors, several agents that act as creditors, and they receive this right from the same person. I believe this is a case where we have to send a clear signal to the debtor to understand which of these creditors is actually the actual one. So what happened in this case? What do we have in the codes for that particular situation? There's an article on the liability, Article 390, was added a provision which clarifies the situation and the relationships between these multiple obligees, specifying which of them will bear the risk of impossibility of performance and which of the creditors is in good faith. But this provision doesn't specify what is it that the debtor can do, in which case the debtor can be held liable. Well, if we follow the logic that was used in designing these provisions, we can say that the debtor in this case can perform his obligations to any of the creditors. But since this is not directly clarified. You can only get to this conclusion by interpreting the provision. And the final point I wanted to make and describe here, when we mention chapter 24, we can see that the number of provisions changed with regard to the replacement of the debtor. It's not that they merged, because we are talking about the civil code. We understand that everything that is not banned can be actually used. But when the debtor is replaced, not only when the two debtors agree on that, but also as a result of an agreement between the debtor, a new debtor, and a creditor. So it's important that the creditor agrees, as you understand. So here we find ourselves with a new form of debtor replacement, and there are very detailed norms on the surety, on the collaterals, and that should remain with the same debt. We had a provision on surety before, but now the same principle applies to the new provision. You're not responsible for the new one until there's an agreement. Now all forms of security can be covered by this provision. And so the question remains whether or not the agreement is necessary for the transfer of security. Yes, it is true, but there are a number of exceptions. And there's a new provision here, a new norm. The security remains if the property that was the subject of security was transferred to the new debtor. So this language was transferred to the new debtor. It is not finished. There's no comma, and we should add the language within the contract on debt transfer. And now, because of this lacking language, we get a lot of issues. I believe this is something that will need to be resolved by interpretation, including court practice. And very quickly, let me cover surety and guarantees. The Institute of Guarantees has changed dramatically, and everybody noted that. But everybody jumps at the large changes, such as the change in the title. But the fact is that even though it bears a new name, it's now not a bank guarantee, but an independent guarantee, but the change is not in the title, really. The change is that we have now more opportunities to use this institute, to apply it. It is now admissible in relations between entrepreneurs. There are no limits to its application. They're not limited to banking relationships, and also the civil code needs to comply with the international standards. Unfortunately, when in 1994 these provisions were written, independent guarantees were still on the way. They were still being discussed, but over the past 20 years there have been some progress, which unfortunately did not get into the civil code now. Even though there is a negative trend today in the overall legal practice, we can say this: you wanted an independent guarantee. Well, it's let's make it a little bit more dependent. Let's make it a little bit more dependent on the secured obligation. And so it turned out that the bank guarantee was basically killed by specifying that if the guarantee is not used for security purposes, and there was one of the cases where this purpose was not determined, then this guarantee is void. And the reference was made to Article 369, where it is specified that guarantee is a form of security. So in order for this institute to work, the plenary session resolution was required, and there were amendments to the civil code were required, where the independence of this guarantee is stressed clearly. It's more clearly than in the previous revision of the civil code. A few words about the surety. I don't know if I actually need to mention this, but the changes that were introduced into the surety section can be divided into two parts. I usually classify all the legal provisions into general, or like Saltykov-Shchedrin said, available for all. So whatever you write, people will still do it. In this respect, we have changes with regard to surety that can be stipulated by law. Okay, well, that doesn't mean that it couldn't have been done without this language. The second type is whatever you say, people will still do it. That's the second type. So there are changes of that kind as well. And I could mention here the following. There is a provision related to the future of the surety and the situation where the surety giver objects to security, and the surety holder can use these objections that belong to the main debtor. And this norm was not changed. It remained in the same language in this latest revision, in the latest version. However, additional language was introduced if otherwise not specified in the contract. So that means that other objections can be used. And I would like to pay your attention to the fact that the Institute of Independent Guarantee actually proceeded from the situation where the surety holder set specific rules, saying that these are the provisions I'm not going to use, in order to make it clearer what the situation the debtor finds himself in. So what happened to this new version? It turned out that the dispositive provision with relation to the objections that belong to the debtor, but unless otherwise specified. But there's also paragraph 5, where it says that the surety holder cannot object, and therefore the deal would be deemed void. So the question is, the paragraph 5, how does that agree with paragraph 1? If this cannot be done, then what can be done? The code seems to open up a lot of opportunities here. What kind of contractual structure could be used? Well, let's hope that this is going to somehow settle in practice, but this latest provision was quite a surprise.
I understand the rationale and what they were trying to avoid here, but I don't think this is the right way of addressing a very practical problem. I think I would like to wrap up here. This was a general review. I would like to add a couple of words on the problem that Aleksandr noted about transplanting concepts and institutions. Yes, we are very fond of borrowing. One of such institutions is the Institute of Assurances is warranties and representations. This is a remarkable concept indeed, and I find it highly attractive because one could spend hours and hours discussing it. For instance, this provision starts by saying that the party that has not provided warranties will be liable in such and such way. Perhaps we should have started differently. Perhaps we should say directly from the very start, somebody is responsible for doing something. There is no responsibility embedded in that provision. It can only be inferred from the wording. In other words, they're not starting at the right place. They're not starting by saying somebody is responsible. So they're starting with consequences, but it's a technical and editorial thing, perhaps, which could be ignored. But I don't see how this is consistent with other principles of civil law that we use. For instance, in this clause on assignment, the creditor is responsible for communicating all essential circumstances when they assign. In other words, does the asset belong to me? On what grounds? Are there any encumbrances? What is the essence of that material right? I mean, is that a responsibility? Is that part of warranties or representations? Is that a specific instance of warranties or representations? How is that consistent? For instance, the sales contracts usually contain clauses whereby the seller guarantees that the property is not under arrest, is not encumbered in any way. Isn't that part of warranties or representations? Is it completely separately? Is it separate? Is it something that only belongs to sales and purchases? So we inserted that concept without relating it to the elements that are already enshrined in civil legislation. Why not tie it closer to the provisions that we already had in the civil code in various parts of it? Because in those places, in those elements, state positive responsibilities. The warranties and representations provision leaves me questioning, what is it that I have to communicate to the other party exactly? I mean, yes, one could think of some common sense things to communicate, but different people may consider different elements to be relevant, materially relevant to a contract. But I am liable. I may be held liable for not communicating essential details, and I will be held to account as a result of that. I mean, they have transplanted this concept, which seems very attractive. Yes, indeed, the obligation to communicate is very important. But on a very practical level, we are confronted with difficulties here, and a lot of case law will be required until this is made feasible in practice. Similarly to another provision which is of great utility, and it's not really a transplantation or a borrowing. This is the provision that talks about the hierarchy of claims in the case of homogeneous claims from creditors. You know, we love interpreting provisions. We interpret them a lot using various channels, but this article is an enigma to me completely in terms of how do we interpret it. Let me remind you what I'm talking about. This is a provision that states that in case there are several obligations, secured and unsecured, with various terms, priority should be given to people with unsecured obligations, and then people whose obligation arose earlier. If I have two obligations rising simultaneously for different terms, what should the hierarchy be? I mean, should the priority be given to an earlier obligation, that's paragraph 3 or paragraph 2 of that particular part of the article? I'm not going to comment on that, I'm just painting the picture here for you. All right, in conclusion, you know, civilists, as I observe, are very vehement people. They love to debate. Therefore, I must apologize, I guess, for being too vehement in my presentation, but I think one should project the problems at this stage early on and resolve them before they will need to be resolved in court. Thank you. I'm sorry, I did not introduce Ludmila to you. I think you all know her as a higher arbitration court judge. She's also the chair of the Intellectual Rights Court. She's the author of numerous publications and books. She has versatile interests, and besides that, she's also one of the main developers behind this modernization of the civil code, including some of the provisions that she herself critiqued today. I think the situation is clear to me. You know, lawmaking is a bumpy road, and you never know which pothole will come next. And this particular instance is very illustrative here. I mean, the guarantees were called banking guarantees because nobody had a proper name for it. Everybody realized that our society, our business entities are not prepared to accept the idea of an independent guarantee when the guarantor is fully liable regardless the actions or inaction of the debtor. That's why they called it banking guarantee rather than an independent guarantee, and that got us into trouble because the central bank said, you're talking about banks, even though you are saying it's not only for banks, but we insist that bank guarantee be relegated to banks only. So it is a bumpy road every time we find something interesting that we have to overcome. Let me tell you that I will be a much greater disciplinarian with respect to other speakers. Please keep to the time limit of 15 minutes most in your presentations. Now it's a pleasure for me to introduce Meyer Guillaume, our French colleague. This is the person who works for the French Ministry of Justice and is responsible there for all matters civil, right? So I guess this is the speaker who is going to share very interesting insights with us, especially that the recent reform in the field of law of obligations contained very interesting elements. I mean, on your side, you addressed the question of protecting the weaker side. We usually say that our law should be more attractive. The French usually say, how do we make it? We try to make it more competitive, and the French want to make it more attractive. Another interesting thing. Today, the civil law reform is in the hands of the government, not the lawmakers. In France, if we were to go down that road in Russia, we would be very critical about it, because the power of government resolutions as opposed to legislative acts is very different. So it is my pleasure to give the floor to Mr. Meyer. Which channels are we using?
I would like to thank you on behalf of the Ministry of Justice that I represent here. I apologize for the delay. Well, now let me restart. Thank you for the invitation to take part in the forum. On behalf of the Ministry of Justice of the French Republic that I represent here, I would like to say that we are really interested in resolving the issues related to various reforms in family law, as well as in the academic law and the law of obligations. In the past 10 years, we have been involved in a number of different reforms. In 2004, we marked the 10th anniversary of the Civil Code of the French Republic, and we realized that it was important to modernize our civil code. The provisions of the civil code were based on the Napoleonic times, and many of the provisions did not change, even though some of the laws were revised because of additional legal documents, but the main code did not they did not show these changes. So it was decided that amendments were needed. There was a revision of the civil law so that all users of the civil code could use those changes. It was important to make the law more accessible, and we developed a number of modifications to the civil code. And just like you said, we are trying to make the French law more attractive, to make the French legislation more sustainable and clearly reflect the obligations. We talked more about the law of obligations in Russia, and I'm sure that the French people are interested in the same issues with regard to the law of obligations in France. This work has been ongoing, and the Ministry of Justice is responsible for this. The first proposals on the reform were submitted back in 2005, and the first reforms were formulated by Professor Catalan, who is deceased right now, unfortunately. This was a researcher, a legal expert, who formulated the foundations for the modifications to be introduced into the civil code. At the same time, no reforms have been introduced. Other professors, other researchers tried to propose their own drafts, their ideas on the reform of the law of obligations, but no reforms followed, even though there were a lot of proposals. Now, in spite of that, there has been some work ongoing, and we have developed the text, which now has become the main subject of discussions over the law of obligations. I will try to give you a very brief description of what provisions will be changed and about the main ideas for this reform, and then I will tell you more about the principles of civil legislation in France. There are a number of issues that are of great interest to you and of great interest to us. There are a lot of discussions in different assemblies and in different forums. The reform of the contractual law remains a political issue in France, and it has been following three main directions. It pursued three main goals. First of all, the contractual law is to be more accessible and easier for interpretation. Even when large companies may not have been interested in such reforms, but the medium-sized and small enterprises that always pay a lot of attention to such reforms were interested in them, and they always pointed our attention to the lack of accessibility, to the lack of clarity and difficulty in terms of interpreting these provisions of the law. So it was decided to replace some of the provisions with the more modernized versions. We placed them in a specific historical order, and they were also placed in a specific methodological order. We have placed them in the order from the point when the contract is signed to the moment when the contract is performed. And all the stages on that way were described in the provisions of the law. The second point that I wanted to cover here is related to the position of the judge. This role was discussed at length. We wanted to make sure that there was a certain form of a legal tradition, contractual tradition at that. If a provision was adopted legally, it should be not just adopted, but there shouldn't be any barriers on the way to its implementation. There are also some aspects, the changes of the parties, the replacement of the parties, have never been described in any legal document, and that needs to be changed. The third example I wanted to give you is related to the following. The reform is trying to balance off the relations between the parties, the contractual parties, and protect the weakest party. Protect the weakest party from the unfavorable economic conditions if the strongest party abuses the fact that the party is weak. As the contract is implemented, if there are any unpredicted circumstances that arise, the judge may recommend to deem this contract null and void and ensure the premature termination of the contract. There was also one other goal, to give legal practitioners more freedom in interpreting the legal texts in accordance with the legal challenges and the realities of our times. What I mean here is the sessions on the right to pay, contractual sessions, in case they are seen as a burden for the weaker party and as a burden that is too expensive. In any case, we try to protect the rights of the debtor as well as the rights of the creditor and the counteragent, the counterparty, and the surety. There were cases when there were questions about whether or not the company may receive certain rights when the company itself was transferred. And so the plan was to take care of all these issues in the reform. In order to do that, we have chosen a special methodology, and on the 16th of February 2014, the French Parliament voted in favor of the bill, in accordance with which, in 1 year, all the rights under the contract will have to be amended, and the modernized versions of provisions will have to be introduced. So there is 1 year to modify the text, as well as bylaws. The debates were very active. The Senate, which is the upper chamber of the French Parliament, allowed the government to take care of this, but the National Assembly, so the Senate was against it, but the National Assembly voted in favor. This is why the government of France, starting February 2015, now has 1 year to implement the reform. We need to formulate what will become the new law, contractual law in the French Republic, and we have 1 year to do it until 16th of February 2016. This is important for democracy, for the symbolism of the French Republic. And as I said, their original documents are dated to the times of Napoleon, and obviously they require changes. Hopefully in a year, any citizen of the Republic will be able to use the fruits of this reform, and before that they will be able to apply to the Ministry of Justice with their comments and proposals.
For instance, Recently, universities presented the Ministry of Justice, and in particular the Minister of Justice of the French Republic, with their amendment proposals that they think need to be introduced into contract law. And it is important to understand that these amendments are not going to come into force immediately after they are presented. And then also, these amendments need to be enacted on the basis of a certain procedure. If the parliamentarians wish so, they will be in a position to change these amendments along the way. Thank you very much for your attention. Thank you very much, and I invite questions now. Does anybody have questions? I think somebody raised their hand. No? Oh, yes, please. And please use a microphone. We need a microphone. We don't have a microphone, do we? Oh, yeah. I have a technical question. How many staff members are involved in processing these proposals? Because there seems to be a lot of proposals coming.
La réponse très officielle du ministère de la Justice français sera un nombre suffisant.
Well, the official answer from the Ministry of Justice is as follows. We have a sufficient number of personnel, but truth be told, it's about 3 to 5 people who process proposals. These are ministry employees. And if necessary, we also contact the universities for extra expertise, if necessary. My department, in particular, the one that deals with civil code, has 5 people. How many proposals have you received in the 2 months of public hearings? We received about 150, perhaps up to 180 proposals. Some were only a couple lines long, some encompassed many pages. On top of that, one should add the various questions and discussions that were ongoing, because the text that we're currently reviewing has been published very widely in economic editions, and there was a lot of criticism through the mass media, and we're also working on that kind of feedback. I think this is a very important question. I think we are just as reverential towards the Napoleonic Code as you are in France, especially that the majority of all the articles there are still in effect as they were written, especially the one that stipulates the freedom of contracts. I don't remember the number of the article correctly. So once you have completed this work and presented it to Parliament, the word you particularly used was ratification. When you talked about enactment, what does it mean? Should the National Assembly add their own amendments, or does it mean that they automatically accept? When a government decree is published, the text published has the power of a decree, and in order to become law, the document has to be ratified. As we say, that is taken through and adopted by the Parliament. The procedure in France is that within a year, after the French, within a year, the during which the French government has the right to initiate proposals. Within that year, the Parliament cannot step in and change anything. However, once the bill is in the two chambers and the Parliament is discussing that, the Parliament can add their own input, but fundamentally the Parliament is in a position to amend these proposals. The role of the government is to propose. They're proposing the 300 articles that will be discussed later on in a democratic fashion. But I would like to underscore here that the mere fact of the government issuing a government decree was severely criticized, because this is an occurrence that has not ever taken place since 1958. I think this is a very encouraging opportunity for our Ministry of Justice, because they will feel that they can really increase their mandate. Well, the lawmaking process in Russia is different. It may be lengthy, it may be onerous, but I don't think that anybody would agree to such a time frame as you did in France, and we certainly would like to wish you a lot of success. I'm now giving the floor to Natalia Raskazova. Again, this is a person who doesn't need to be introduced to this audience. For many years you have known her as a great authority, a professor at the St. Petersburg University. Many of you remember her practice before teaching. She is a member of the Codification Board under the government of Russia, under the Russian president, a board that aims to improve civil legislation. She is currently in charge of the law school. So please, Natalia, let's talk about those obligations, and perhaps you will be in a good position to put the different pieces of the puzzle together, because after all we will again disassemble the puzzle we're going to discuss shortly after. So please try to put the puzzle together. I don't think I would be able to address such a global task in the limited time that I've been given. I'm not going to talk about securitized obligations, but rather address a few general observations. First of all, what's the current state of liability law as per the newly adopted amendments of Civil Code that are going to come into effect in a couple of days from now, on the 1st of June. The 1st of June is when I'm administering an exam in civil law to my students, and imagine the difficult times our students are having these days. We had pre-exam consultations with them, and they were extremely frustrated, and as a teacher of civil law I said, well, of course I don't expect you to know every nook and cranny of the new amendments when you come to the exams. It will be too early. But what do we have? Well, of course, it's evident that the new version is a patchwork. It only takes a brief glance at the text to get the impression that this is a result of some difficult battles that were never resolved in the end. And perhaps it was a matter of really trying to snatch the baton in that race that determined which side would prevail. So it is a patchwork, and perhaps this should be the way, because it's a result of compromise. I don't know, because to me this new text cannot be interpreted using the traditional interpretation approaches, and interpretation is what we thrive by. For instance, if our interpretation leads to completely irrelevant words, symbols, or letters appearing in the law. That means our interpretation is erroneous. And if you try to interpret these new provisions, you will have to leave the profession because you will never be able to interpret. So it's uninterpretable. Another observation I would like to make is that, yes, of course, case law will prevail in the end, but at what price? Let us agree, case law is a valuable source of interpretation. It's the driver of legal development. However, not all case law actively contributes, because we live in a vast country. Look at all the parts of Russia and the cities we have here. The city of Urupinsk, with a ridiculous name, is a real city. I don't know if you're aware of that. It's a city on the banks of the Volga. Do you know the level of the legal practitioners that work there? And it's a very upbeat city, by the way, very optimistic city, but they have lawyers who graduated from law schools locally. And those law schools are not really self-standing law schools. They're mainly branches of bigger universities, those universities being agriculture universities or other non-legal, not very well established schools of learning. So what about interpretation in those places? What about the legal culture of the thousands of people who are going to be the users, who are going to work and apply the law? What about the small and medium-sized businesses who will one day have to open the book, read the legal provisions and understand those provisions in one way or another? I think it would be completely erroneous to say that we're going to interpret everything unambiguously. Despite the modern exchange platforms and technologies, it is an illusion that we will be able to teach the whole country, the whole nation, to apply this ill-formulated new text.
Well, let's then accept that everything that was introduced into the text, and I don't think Yuri will not probably agree with me, but the way he says, from the best of expectations, with the best intentions, and that's what we have now. Obviously, those who have been involved in the process and that is Moscow, St. Petersburg, the University Center, Ekaterinburg, again as the University Center, all of these university centers will have to do everything in their power in order to make sure that this is used to the benefit of the country. I think it is a very difficult situation, not only because there's so much work, because we could say, oh great, now we can, do all kinds of interpretations, we can now write our own opinions, but it's an illusion. It's an illusion that several dozens of people will be able to explain everything, because the law will take on a life of its own. The banking guarantee is one example. Let's see what it becomes in practice. I think we need to clarify the situation. And if all of the people who had any involvement in the designing of this law, and I'm looking for a word because I don't want to say anything against these people, or I don't want to sound as if I'm trying to give reproaches here, but as I followed this process, I think it is important to take more account, to listen more to advice from experienced colleagues. I mean advice from Aleksandr, and I heard you say, you give your proposals on a number of occasions to what Benjamin Yakovlev says and other people like that. This is the golden rule for legislature. If you want to introduce a change into the law, it has to be done only if there is a life-threatening condition. Just like surgeons, they have to remember that any intervention is an operation. It's a cut, and therefore there will be a scar. the second rule. If you want to amend the law in a life-threatening situation, you have to make changes that have at least been tried in practice. People say that lawyers are conservatives, and that is what makes this profession. But the conservatism is not a reproach. I believe that a good lawyer is a traditionalist, and I may be wrong. We have a group of people that we would call civilist extremists, usually young people. They fight against conservatism, and I can see a group of people in the back benches. I can see that in that corner over there. But conservatism is at the core of our profession. It does not mean that we are retrogrades. It doesn't mean that we are too slow. But we have to be careful when we change the legislation, because we are talking about millions of people that will read this language. And it's very difficult to foresee what consequences these changes may have. So if you want to introduce changes, you have to introduce only things that will be acceptable by practitioners. And one of the examples of how the practice treats these changes, again, from the best of intentions, these changes were introduced, and the banking guarantee is a very good example of this case. The bank guarantee can mark its 25th anniversary soon. It's a girl ready for matrimony, almost 25 years. And together with my students, I follow the trends with regard to independent guarantees. And I always mention my students because that makes it possible for me to read hundreds and thousands of texts. We take texts from the courts, from clients. Our master degree students are all lawyers, so they work and they see different documents. 70% of bank guarantees are used in the country. Again, 70% of all the bank guarantees that are used in the country, not the bank guarantees that are offered by large legal firms to their large clients, but the normal situations. So over 70% of these guarantees contain a language. If the principal does not perform on the main obligation, the guarantor takes on the obligation to pay. So it's actually a surety. It's the same language as an surety. If you're skeptical about it, I have these documents in my computer. I have all these guarantees year by year. I have a whole collection. The judicial practice, the judicial cases will somehow resolve this, but I'm telling you how the practitioners take unusual, unknown provisions. So it's 20 years since the guarantee was introduced, and people still do not understand it. And now we are going to have an independent guarantee, which will be put into force since starting June the 1st. I actually like most of the amendments that were introduced in the Civil Code. And to a degree, they correspond to the document that should have been the source of these changes, the unified rules on bank guarantees, revision 758. And one more note that I wanted to make on borrowings. In 1994, the bank guarantee and the provision on bank guarantee was a translation of the law on the International Trade Chamber. And again, I'd like to confirm that if there are no changes, if the changes are made, let them be made only when it is absolutely necessary. And if we want to borrow something, we have to be very careful. So if we borrowed the language and the international legal text by the International Trade Chamber were very carefully worded, but we just took it word by word without the context. So what are we going to have starting June 1st? The independent guarantee should have a number of conditions. The the circumstances under which the amount should be paid, when the guarantor can refuse to perform on the obligation. If the claim does not meet the requirements of the guarantee. And what are the requirements? The circumstances that would lead to the payment. So this is the text, this is the language that we have in the Civil Code. So how does that issue get resolved in the original text? The text of the International Trade Chamber, from where this language was mostly borrowed. Banks use these uniform rules. Article 7, non-documentary conditions. The guarantee should not contain conditions different from the period or date in the document confirming the performance on these conditions. So the unified rules contain a very clear explanation and a justification, because these rules reflect the many years of experience. So an independent guarantee cannot be a justification for a payment depending on some kind of circumstances that cannot be checked with the help of documents. I take this document, the document should contain this information, and this document contains this information, that should be enough. Obviously, when the language was formulated in the bank guarantee provision, nobody, and I'm absolutely sure of that, wanted to depart from the main principle, the independence from the main obligation. But I showed to you what we have come up with. Why did it happen? It's difficult, and it's a different matter entirely. But in the old language, this was not in the language, so I think it's a deficiency of the new formulation. People realize that you cannot pay because the main obligation was not paid for. But what is going to happen now, what people will come up with, it's difficult. The Supreme Court will make a ruling, but the normal people who will use this language in government procurement process and other contracts, what does that come as a result of? Possibly a murky process of the development of the bill design. Yesterday we held a roundtable discussion, which was called, what was the name of it? The legal consulting. I hope that I would be able to hear something about the law on government procurement. I wanted to get an answer to my question, why is it there is no procedure for adopting such a law, and there was no answer to that.
So what should be done? And who is to blame? Well, I think everybody is to blame, really. I think we'll agree that one of the most powerful tools that to influence social and political processes is public opinion. For Russia, the role of public opinion is almost not there. It's a miracle. It's a phantom. I mean, there is a certain consolidation in public opinion in certain fields, but this is not enough. The public opinion should be influencing those officials who are responsible for the drafting and enacting a law in Parliament. So I don't know what exactly should be done, but I think one straightforward step would be to issue commentary now that would explain not what is supposed to be done, but they would possibly provide the rationale for each particular provision, why it was inserted. But this is also a communication problem. I don't know if we can get back to each of the authors that were behind these formulations. Regarding security payments, I would like to say a couple of words about that, because it also illustrates the golden rule that I already shared with you. Don't amend a law if you can do without it, if the practice is working okay, don't make any changes. So where does this security payment come from? How did it emerge? It didn't emerge from civil law, it emerged from tax relations. If you open the tax code, it says that if an amount was provided as security, it's exempt from taxation. So it stems from taxation. In other words, you have to make an advance payment now. And why do you pay in advance? Why do you pay up front? You make that payment as an additional guarantee that the creditor will be paid for works or services rendered. But once you make that payment, it becomes taxable. And if you call it security payment, it is explicitly exempt from taxes. It makes sense, but it's part of taxes. Why included in civil legislation? I myself could not formulate a single sound reason for inserting it there. Well, people told me sometimes security payment can be made even before the main obligation, the principal obligation arises. We couldn't do it earlier. I don't know why it wasn't possible earlier. If I make a payment before an obligation arises, it is impossible to say that this is unjustified enrichment of the recipient of that payment. It's difficult. That money is not unlawfully retained. So from civil law standpoint, I don't see why it was inserted. Now that it is inserted, what has changed? I make an advance payment to you. I call it security payment or earnest payment or whatever. What is going to change in case I go bankrupt or you go bankrupt? Because if there is a group of creditors and there is a wave of bankruptcies, that certainly gives you some privileges, but in the situation I have just described, it makes no difference. That's why I see no point in introducing a security payment into the civil code. And if it is to be introduced there, it shouldn't be part of the obligations section, because there is no substantial difference as it stands now between security payment or advance payment. Yes, we are resolving a few minor issues in taxation, but why do it in civil code? My time is up and I'm ready to take questions. Thank you.
Два слова буквально, чтобы, так сказать, может быть, те, кто не знает, как проходило все.
I would like to intervene very briefly just to describe to you the work process. The drafting efforts to modernize the civil code was completed on the 30th of December 2010. So it was 2010, but this was followed by a lot of disagreement between the codification board that was owning the text and presented it to the president, between the board and the Ministry of Economic Development. There was different interests at stake there, and there was a disagreement which went too far. The role of the umpire was given to the Ministry of Justice, which had to act as an arbiter, as an umpire in that discussion. The ministry did not have or defend any position of its own, but in the process of that conciliation, we obtained the things that are currently people are criticizing currently. The procedure is actually very well documented, so if you go back to the sources, you will easily trace these amendments back to their very origins. What happened eventually was the bill was presented to Duma. It took another 6 months to complete drafting work. By July 2012, it was finalized, which was again followed by a lawmaking limbo, a period of time when it's difficult to say who exactly was introducing last-minute amendments to the texts. I'm now give the floor to Ms. Makovskiy, who is the head of the Research Center for Private Law. She's a member of the Presidium of the Higher Arbitration Court. She's an ex-Higher Arbitration Court judge. Please, over to you. You're also going to address a very controversial topic about termination of contracts. There have been changes in those provisions as well. I don't know what you think of those changes. I think those are somewhat better quality than the ones we discussed.
Thank you very much. I would like to start with a different aspect, the aspect that is related to the participation in this roundtable of representatives of the French Republic, people who work on the reform of their civil legislation in the area of contractual law. So if you look at the publications in the press, if you look at the issues that are raised, at the relevant issues that attract attention of French lawyers, then you will see that one of these issues is the introduction of a provision on one-sided termination and change of the contract. Let me say from the very beginning that this is a provision that is contained in the published draft on changes to the civil legislation, is not the kind of one-sided termination that we have in Russia. In France, there are two different approaches to the termination of the contract. One is related to the conditions in the contract about its termination and the termination that becomes a result of a court decision. So that the law has always had a question. What if you don't have any conditions on the early termination of the contract in the contract, and then we have to take it to court? Should the Civil Code of France contain a provision that would help you, and if there is no need to go to court and no conditions, is it possible to terminate this contract? It's a very specific structure. It's a construct which is being discussed right now. I'd also like to pay your attention to one very interesting point, which is a very interesting point, which is now also related to the Russian legislation. In accordance with the current civil code and in accordance with the proposed amendments, this unilateral termination is allowed only in one case, when there is a significant violation of obligations of one of the parties, of the other party. Now, you may remember that the Russian civil legislation, from the moment when the first part of the civil code was adopted, there were always two main provisions. The two provisions that are related to the changes and termination of an agreement and a contract. It's the Article 310 and Article 450 of the current civil code on the termination of contracts. And one of the most actively discussed issues in the corridors of the Supreme Arbitration Court was the issue of the relation between these two articles. And I can explain why. Any lawyer is aware of the fact that in the current Article 310, there is a very rigid structure that specifies that any unilateral dissolution of the contract is not legal, but when there are entrepreneurial contractual relations, there may be grounds for the termination that would be contained in the nature of obligation itself. The Article 450 did not have this caveat, and those present here will not let me say it's wrong, because the discussion was about this. So the differences in the language between these two articles, may that mean that the contracts may provide grounds for a unilateral termination or change, that perhaps this can apply not only to entrepreneurial contracts, but also to any kind of contracts. And there was also one additional problem. Now, if we, and that was one of the ideas, link Articles 310 and 450, if we do not look at them independently, but look at them as a comprehensive regulation, then what does it mean? Article 450 contains 3 rules, and the concept of the current Article 450 was interpreted as an article that provides for 3 ways to terminate the agreement: upon the agreement, through the court decision, and unilaterally when one of the parties changes or objects to the obligation. The practice of the Supreme Arbitration Court says that if there is any link between the articles, then it is the link between Article 310 with paragraph 3 of Article 450, which is referring to the unilateral termination, the unilateral refusal. So from this point of view, it is important to point out that the current civil legislation, the current civil code, and the draft that will be put into operation in 2 days has divided Article 450. Now the rule on the termination of contract by agreement and by court decision now are in Article 450, but now there's no reference to Article 310, whereas the rule on unilateral, without the court decision, unilateral refusal, partial or full, with a reference to Article 310, is now a separate article. It is Article 450.1. So I would say that the limitation that currently proceeds from the ideas formulated in Article 310, that the foundations for the refusal from the obligation may be specified in the contract if the contract is concluded by the entrepreneurs, or they may be specified in the contract where one of the parties is not an entrepreneur, is only about Article 450.1. And I will explain why I wanted to stress this. This means that if I don't have this limitation, then if my contract specifies foundations for the termination, even if this is not an entrepreneurial contract, then it's a different matter entirely. So this shows that the rule 310 can be applied in conjunction with 450.1 and cannot be applied in conjunction with Article 450, which does not mention unilateral termination. The second point I wanted to make. So, what does it mean when you can specify foundations to take this termination of the contract to court? What is the out-of-court refusal? Can we say that this is a unilateral extrajudicial termination? Well, the people present here will confirm that we had a case in 2008. It was quite a famous case. Then there was another case in 2010. This was the issue of the assessment or evaluation of the contract conditions. This was one of the biggest banks, Sberbank. It was a lease, and the lease agreement provided it with a right to, at any point in time, to unilaterally terminate the contract. The collegiate of judges took it to the higher arbitration court because this is a right without any foundation to have an extrajudicial unilateral termination of the contract. And the Presidium of the Higher Arbitration Court went down the Article 310 line, making this connection. And that rule allows the parties of entrepreneurial contract to specify conditions for extrajudicial unilateral termination of the contract. So it's not a violation, it's not even a special circumstance. I want to have this right. I want to have the right to terminate our contract at any point in time without any special foundation. From my point of view, by supporting this contract, the Higher Court of Arbitration gave its own interpretation. Because if this understanding is valid, if it actually is contained in Article 450 and Article 310, then why should there be any other different interpretation for a situation whereby the contract contains the conditions for taking this matter to court? Because in terms of terminology, it's not much different. There's no differences between paragraph 2 and 1 of Article 450. Any foundation can be used here. I'd like to pay your attention to one point here. Yes, it is difficult when you have the right to unilaterally terminate the contract. Whether it's in court or out of court, it doesn't really matter at this point in time. But from my point of view, it's even worse when the participants have a unilateral right to change the contract, because any lawyer here would agree. From the point of view of a letter of civil code, there are no limits onto which conditions of the contract can be changed when they have this right with the help of Article 310 and 450. Unilaterally change, let me underline that. So why don't I change all the contracts that I entered in from the beginning to end if I have this right? This is an entrepreneurial contract. I take it to court. I can ask the court to change it. I have this right. I have this right to change the conditions. So in this connection, I would like to make a reference to a very careful position of the designers of the French Civil Code, the amendments to the French Civil Code. They were very careful about introducing a new rule of the unilateral change of contracts. I'd like to pay your attention to the fact that based on the draft legislation, the unilateral change is only possible with regard to the price. That's the only condition. And the second is that this right is granted under in 3 types of contracts. The contracts where there's a the so-called droit concessif. These are the services contracts and the framework contracts. But there's one more thing. The draft language provides for such an opportunity. The creditor may change the price unilaterally, but at the same time, this creditor will have to prove the justification of this change. So basically, the debtor is protected. If we look at the new rules in the Civil Code, and I will try to wrap up, I believe that there are 2 main mechanisms that can be seen as complicated mechanisms that aim to protect the debtors from the abuse of this unilateral determination or unilateral change right. These are articles 450, 451. If a person has the right for unilateral termination or change of the contract conditions, this person needs to realize this right in good faith, being scrupulous. And then you can ask, how? If you have this right, what's in good faith here? This contract basically means that the debtor will need to act against the relevant activities of the creditor. And there's a second contract, and this was mentioned at the beginning. This is a contract, a system that may help the debtor, against which there is this right to unilaterally change the contract. Based on Article 422, there's a contract in the accession contract that if there is a condition that violates the balance between the obligations and rights of relevant parties, then one may ask to change the conditions of the contract or terminate the contract.
But please understand, Article 425 only concerns adhesion contracts. It does not apply to other types of contracts. Sometimes my colleagues tell me, well, who is going to sign a contract where the other party has the absolute right to unilaterally amend or terminate the contract? But Sberbank has signed that kind of agreement, and here in this room we have two people who acted as my sureties before Sberbank some time ago, and they made a surety contract. Of course, they honestly relied on the debtor fulfilling its obligations before Sberbank, but if that proposed surety contract contains Sberbank's right to unilaterally modify the terms of the contract, those two sureties were individuals, not legal entities. If they had been legal entities, would they have been able to make any objections to that? I mean, we're talking about situations where there is a prevailing party that dictates the terms. What about surety? It's the surety holder that usually dictates the term. So when I talk about that, I usually say it's great that our surety holders have in the back of the mind the requirement that these contracts can only be modified at the consent of the parties. So these are some of the highlights I wanted to make regarding the amendments that are coming into force on the 1st of June in our Civil Code. Thank you. I'm now going to give the floor to Mr. Novak. His role is very similar to that of Monsieur Menyer's, only he works for the Russian Ministry of Justice, and I think the next French speaker will be given the floor right after the break, followed by presentations from our German colleagues. Please, Mr. Novak, because you're also going to talk about the strengths and weaknesses and the balance of strengths and weaknesses in a contract. Thank you very much, and my colleague said that a commentary should be written providing rationale for these amendments. I think I will try to begin this unthankful job of trying to explain how come we have articles 406.1 and 432.1 in the Civil Code. Now, I would like to start with an anecdotal story. I was following the press, and in April 2012 I saw a report on the internet. The Russian president will forbid the sale of imported cars. And that got me wondering, why would anybody ban foreign cars? So I clicked on the link, and it seems that that article was informed by this new provision on assurances and on warranties and representations. And the journalist said that finally we have a provision that under which you can claim damages that protects you, but the second-hand car market is based on this kind of cheating, because people purchase a second-hand car and then they sell it as a new car after a few major repairs. So if that is banned, if people are held liable for those practices, the market will collapse, and that means that it will be equivalent to an effective ban. So that's how far they stretched it. But the question arises, didn't Civil Code of the Russian Federation already contain mechanisms to protect against fraud in contracts even before the amendments? Isn't something really new? How could the original authors of the Civil Code not taken this into account? Well, of course, you will tell me that the Civil Code has contained these protections for over 20 years by now. Which protections? Well, of course, fraudulently induced transactions can be deemed invalid and claim damages. You know, the problem with that was that and this is typically Russian, the courts were very conservative, and they only very rarely invoked this Article 179. There were very few positive rulings where a transaction would be annulled, deemed null and void. So this is a mechanism that was underused. They only used it very rarely. Therefore, the businesses, the industries, did not regard that provision as an adequate protection because it was not enforced by courts. Of course, they could have done it differently, and the Supreme Arbitration Court at the end of 2013 published a review on the application of 178, 179 articles, and they described in great detail this used car market situation there, and I think they made their statement very clear. But you know, Russia is borrowing foreign practices, but we're not the only country. I remember a couple of years ago, there was a roundtable at the Supreme Arbitration Court. Our German colleagues said, yes, we do a lot of borrowing as well. We also transplanted warranties and representations from the English law. Why are they doing that? Well, for purely psychological reasons. He who pays the piper calls the shots. If you have an investor coming into your country, an investor who is used to having warranties and representations in the contract because they see it as an adequate safeguard, they are not going to sign a contract that contains references to some obscure Article 178, 179 in the civil code of an obscure country. So when we talk to foreign investors, they simply don't understand it. That's why they don't invoke these instruments. On the other hand, they say that if you have enough money, the lawyers, our lawyers, can oblige you and use these channels as well, because legally you can use whichever mechanism you want if that does not contradict legislation. So, in other countries, they insert foreign provisions into the contract, and all you have to do is pay something extra to your lawyers, and they will insert that into your contract. If you don't have enough cash to pay your lawyers, simple people can use our traditional German clause on fraudulently induced transactions. So this is not a unique situation in Russia. It's a trend that other countries are experiencing as well. Well, of course, still, rather than plainly transplanting items into the civil contract, Russia could have changed the contract practice, but the businesses are not prepared to that. And what if we have this blended contract? What would the court think about it? I mean, if we had contracts discussed in courts claiming damages, the court would say, where is the violation? Because the obligation was to act or refrain from acting in a certain ways. There is no space for claiming damage here because formally no violation of the contract or has taken place. So that's the practical reality that has led to these new provisions. So let's now talk about the nuts and bolts of them.
Ludmila Novoselova already mentioned and asked, where is this obligation? Where is it written that you need to say the truth? Because then you have the responsibility for some surety. And now the Civil Code, then the new revision actually has it. Article 307 has paragraph 3, acting in good faith, the provision ensuring disclosure of information, and Article 334.1, there's now responsibility for entering into contract, and it's written there that parties should act in good faith in negotiations, and incomplete or irrelevant information can be deemed as the violation of this rule. So what's been happening? What's happened? We now have a lot of competing institutions and methods to protect the parties from fraudulent contracts. 179. Now there will be contractual responsibilities. A new article. And more. In fact, I think we could have lived without this article. And in different types of agreements, you have some elements of this protection. Quality of goods, quality of products, insurance. I will tell you about insurance when it comes to recovery of losses. There are many other elements, and it's strange that we have so many different elements that aim at the same. The only thing that is lacking is that the warranties and representations article has the language that the party in entrepreneurial relations will be responsible not only for actually cheating, but also for the guarantees and presentations that they believed to be true at the time. And it is important for the contracts. One of the parties is very interested in having the contract placed, and the second party needs to be convinced. And then you say, okay, you think that maybe the license is not here, is not in place, or the financial situation may not be good enough, that there may be some tax claims. And I sincerely inform you that we meet all the necessary requirements and that the situation that we present is true, otherwise your losses will be recovered. So that's the only thing that is not covered by Article 179. So basically the misrepresentation that happened involuntarily is also covered by the new article. And Natalia also prompts me to say that there's also the issue of risks. One more rule is important, and we need to mention it here. The responsibility under this article only happens when the party misrepresented that misrepresented information acted and had reasons to act this way. Well, let me give you a situation. We write each other messages about the construction of a pipeline, And during the negotiations, I said that I assure you that the day before yesterday, there was a polar bear that was born in the Moscow Zoo. And I assure you this is true. And it's possible that this is exactly why the contract was placed. Had it not been for the small polar bear, then there would not have been this contract. And now, since the party used it reasonably as a foundation for its decision, then it's very difficult to prove. And now, going back to a more difficult situation. I can't see a lot of big problems here. There may be some glitches in the enforcement, but I have 5 minutes to discuss Article 406.1. This is with regard to the distribution of risks. Well, obviously, if are not otherwise specified, the risks stay with the person who assumed these risks. They can be transferred only if the law specifies it or if the contract redistributed those risks. I believe that what's written in this article could have been left out using the freedom of contract principle. If it was impossible to take on the obligations and neither of the parties is to blame, for example, the sanctions, then the losses incurred in relation, or the claims in relation with this, all these losses will be compensated. You can introduce this in language in the contract, and it is up to the parties to distribute these risks. But what will the judge say? The judge will say, well, there was no violation. It wasn't him that violated this, it's the third parties. So no losses, and then these losses cannot be recovered. So this condition should be deemed void because, well, and we're not talking about losses, we're talking about a different thing. We say that even though the violation is not there, the risks were assumed. So now we see that everything has been done in order to differentiate between this institute and the losses. The different term is used, and it is written there that they are not related with the violation of the parties of the contractual conditions. People do not always understand the difference between this provision and the insurance. And yesterday we discussed a similar thing at a roundtable discussion. Some people say that this is very close to surety, others people believe it is close to covenants, and yet others believe it is more like insurance. But there's a big difference with insurance. In insurance, the losses will be compensated not by the contractual party, but by a specialized organization. In this case, in our case, we're talking about the recovery by one of the parties. Well, there's also the third-party losses, but I think it should be interpreted not separately, but in link. For example, the losses incurred by the association where I have a share in. But it's different from insurance. And my colleagues have already agreed on how is it possible to provide an indemnity by the third party. Well, we have an independent guarantee. We will issue the independent guarantee to the third party, and then we'll do the same thing. And I have to warn you, I don't know what the regulating authorities will think about it, because they can deem this as insurance which is being done without a special license. I would warn against such practices. I think there is a certain risk in this. So what else happens to this article? I'm closing my presentation. When this article was first introduced into the Duma for the first reading, there was a consultation with the businesses. This language was revised mainly by Mr. Vetriansky. And many people were dissatisfied. Why is that in the English law you have this and that, and we don't have it now in this article? So what happened next? People tried to push forward, trying to introduce things that did not manage to get in the article in the first case. And there were a number of strange things happening, because let me see, look at the list. Originally, this article gave a very direct reference to the limit of the recovery of losses. And there was a reference to Article 15, that the losses are defined under Article 15 that did not, were not incurred because of the violation. And there was another Article 404 that about the losses that were incurred because of the behavior of one of the parties. This is a very Russian issue. We know that we have problems with proving what losses are all about. I think the business community decided to get rid of this complication, and they wanted to have a clear language. They didn't want to have the court determine the cause and effect. They wanted to have a specific figure mentioned in the legislation. So what happened? We now have the language as follows. I think it's a slowly working mine. There should be a procedure for determination, and the judge cannot lower the scope of losses. The reference to the article on losses was taken out. We look at the English law contracts, we see that the losses are never determined specifically. They say all the losses incurred because of blah, blah, blah. All the recoveries that may occur because of certain circumstances. But they never contain the language that there will be 1 million rubles to be compensated for. It's losses, not a specific amount of money. And in this case, if we have 1 million rubles and losses were 5 rubles, then the court cannot even take it down to 5 rubles. It's only possible to recover only 1 million rubles, even though the losses were 5 rubles. This is a mistake. This is a misconception. I believe that we have to be reasonable, because the legislators did not mean it that way. I think if we stopped at the procedure or methodology for calculating these losses, this would have been enough.
And I must say that the courts have recognized that. Very soon the Urals District Arbitration Court Consultative Board will convene. They have already provided their commentary, and they say quite reasonably that if an indemnity situation arises for an amount that exceeds the actual amount of losses incurred, there is the provision in Article 10 of Civil Code whereby it is unacceptable to derive benefits from additional benefits from damages. So this is the general direction that the courts seem to be taking already. And another problematic statement embedded in these articles is this. If an agreement between the parties should specify the damages or the indemnity amount, I think this is controversial, and I don't know what the courts are going to say. There is a danger in this wording. The courts may treat it as a material condition, a material term, and they will be very strict. I think a better way would be to say all damages arising from this or that. Therefore, I think this new concept will play an important role in terms of attracting new investments, and hopefully the case law will overcome the inconsistencies and problems. I will allow myself to add just a couple of words. I'm sorry for drawing this out. Please note that this is a very illustrative example of a very straightforward approach to transplanting, mechanically transplanting elements of other countries' law, because what this is at the end of the day is purely insurance. Why is it they're talking about damages here? The insurance premium. That's why a risk, the absence of creditor's guilt, it's an insurance situation, but a partner that includes that provision in a contract is interested in it because it will be cheaper for them than claiming insurance, and I'm afraid there will be a lot of outrage coming from the courts when they are faced with these situations in real life. Thank you.